At its meeting on March 15th, Town Attorney Tom Harrington presented to the Select Board the major findings of the report written by Boston attorney Natasha Tidwell, which concluded the officers did not engage in racial profiling when they stopped Marvin Henry in January 2020. But it also said that it was unclear whether a probable cause existed to detain Henry, and it was against the Needham Police Department's own policy to search him. Police Chief John Schlittler said they should have better communicated with Henry after the incident and regret any distress this caused him. But he believes that the officers' actions were lawful based on information provided to them on the scene. The Select Board meeting did not include public comments, but grassroots community action group Equal Justice in Needham held a forum to discuss the investigation. They invited Stephanie Hartung, a Needham resident and Northeastern University School of Law professor, to speak on the report because she has a background in criminal procedure and criminal justice reform. Hartung spoke with Municipal Producer Yuxiao Yuan on what she believes deserves further examination.
First, I want to talk about the handcuffing. Ms. Tidwell did find support that Mr. Henry was handcuffed almost immediately upon approach, and he was handcuffed for almost 30 minutes. So what is the general policy of handcuffing, like adopted by law enforcement across Commonwealth, and was the measure taken here reasonable and necessary?
The general principles are that handcuffing is to be used in the case of a danger to the officers or a fear of flight. And from the record that we have, it doesn't seem that there's evidence of either of those things here, where certainly there was no allegation from the call-in from CBS that there was any kind of weapon or violence involved in the crime that was alleged to have been occurring. And by all accounts, Mr. Henry was cooperating and trying to provide proof of his innocence. From all the reports that I read, I didn't see any account that suggested Mr. Henry had tried to flee or anything else that would suggest the need for handcuffs under these circumstances.
The officer also admitted in the internal investigation that he pat frisked Mr. Henry for shoplifting evidence from CVS. So what is the policy of pat frisking, and is it proper here in this case?
Sure. A pat frisk generally requires a reasonable belief that the suspect is armed and dangerous. So it's a preliminary search that occurs absent a full arrest with probable cause. Here, again, from the record as I understand it, from the various sources that I've read, there wouldn't be any cause to believe that Mr. Henry was armed and dangerous at the time, or that he was carrying any kind of contraband. Even the allegations from the CVS employee who called 911 didn't allege that the suspect had left with stolen items. That was never part of the claim. So there's really no basis that I could see for a pat frisk under the circumstances, and certainly not one for weapons.
Professor Hartung found the conclusion of no engagement of racial profiling questionable.
It seemed in reading the report that what was clear is that Mr. Henry was detained as someone who only met the description of the suspect in terms of his race and his gender, and virtually nothing else. If you've seen the photos that are in the Tidwell report, you can see the physical difference between the two men, between the actual suspect and Mr. Henry. The suspect is quite large and big in build, which is how the 911 call description came in. He also is wearing a hoodie, which is what is described. And Mr. Henry is a medium size, medium build, who was not wearing a hoodie. So what you're left with is just a description of a Black man, which sounds very much like racial profiling. But what's even more troubling than that is that the report spells out all kinds of ways that the officers on the scene failed to try to follow up on the various pieces of evidence that would have supported factual innocence. And what they seem to do is ignore each one of those things, including the receipt Mr. Henry had on him, the fact that he didn't meet the physical description, the fact that where he was parked would not have matched the MO of the alleged crime, which involved typically leaving the CVS with a full shopping cart of stolen items. And Mr. Henry was parked down the street and you would have to cross a crosswalk with a light in order to get there. So none of those things match the description of how the crime was alleged to be occurring. So there was a plethora of information that pointed to Mr. Henry's innocence that was ignored.
Professor Hartung also found the Select Board's response to the investigation at its meeting on March 15th unconstructive.
The emphasis at that meeting very much focused on the big picture conclusion that there was, quote, no racial bias, but there wasn't really much a discussion about all of the other troubling findings and facts in the report. So I think a careful review and exploration is warranted here under the circumstances.